Okay, so Maracia, is that how you say your name? He's not here yet. Say your last name for me, please, counsel.
Correct, Your Honor, Maracia.
Okay, so you're first. You're going to reserve 5 minutes?
Yes, Your Honor, I would like to.
Okay, we're ready whenever you are.
Thank you. May it please the court. My name is Stephen Maracia. I represent Travel Insurance Facilities PLC in this case, the appellant. Now, thank you, Your Honors, for taking the time. Appellant in this case contends that the lower court erred in denying appellant's motion to dismiss for lack of jurisdiction. Now, the jurisdictional issue presently before this court centers around a fundamental tenet of our judicial system in general beliefs and principles as Americans, that is due process and fairness.
Well, sir, your argument is very intriguing. You basically represent a client who basically, issues travel insurance for people who want to travel in various places. And if they get sick, they go into the local hospital, they get treated, and this insurance is supposed to pay for them. But yet your argument is that those jurisdictions won't have jurisdiction over your client in their efforts to collect the bill when they want to do that. So it's sort of a odd thing. On the one hand, your client's in the business of insuring these people who he knows is going to go all over the world. And if they get sick, they go into a local hospital, they get treated. When the hospital wants to get paid, your position is that your client can't be sued in that jurisdiction. Yet that was that's the business they contemplated being in. And that basically it?
Well,
so they can only be sued in the UK or the Channel Islands? Is that your position?
Well, our position is that the minimum contacts have to be established, Your Honor. That due process calls for minimum contacts being established by the plaintiff, which include purposeful availment and foreseeability, which has not been proven in this case. Now,
well, wait a minute. The complaint alleges certain minimum contacts, and this record doesn't have an affidavit of your client which is traditional in this context, setting up some sort of dispute or their version of the facts regarding minimum contacts. How are we supposed to work with that on the request that you're asking us
Your Honor,
us to do?
In the Supreme Court case of Venetian Salamoni, it was established that minimum contacts are not built into Florida's long-arm statute. So once long-arm statute is pled, then there'll have to be due process that has to be pled and established as well. The court can only acquire personal jurisdiction if the non-resident has minimum contacts with the forum, such that maintenance of the suit were not offensive.
But you're not focused on my question. My question is, wasn't the trial court, absent any contravening evidence to the allegations in the complaint, entitled to rely on the allegations in the complaint?
Yes, but the appellant is not contesting the jurisdictional facts raised in the complaint. Appellant is not attempting to inject factual matters which do not appear on the record. Appellant is simply challenging the sufficiency of the pleadings. Now, you had referenced that there were minimum contacts established, but obviously we would disagree. The appellee will ask the court to blindly confirm that by simply pleading that the contracts and services upon which the action is based were performed in Florida.
Well, that's paragraph 5 of the complaint, but what did you file that was part of the record that contradicted that?
Well, we're not trying to contradict that. We're not.
Well, an affidavit usually works.
Of course, but
because that paragraph says that you provide insurance for people knowing full well they're going to go to Naples. Call your county.
Well, I would disagree that particular paragraph says that we know full well.
I'm not sure what else it says.
There's no allegation that my client, the foreign insured, had any idea where these individuals were traveling at the time that the policy was issued. Even this particular court, the second DCA in Osborne versus University of Society, decided that even though the complaint met the long-arm statute bare requirements, there remained constitutional issues that need to be considered.
But was that reversed and remanded or reversed?
I believe it was. I believe it was reversed and remanded.
Is that what you're asking? Or are you asking us to reverse outright?
I'm asking you to reverse outright,
Based on what?
based on the fact that, again, there's a failure to establish the minimum contacts here. In that case, the Osborne case, the court found nothing in the complaint indicating that defendant availed itself of the privilege of conducting business. In that
But the
particular
test for minimum contacts is set forth in Volkswagen versus Woodson. Is the defendant's conduct and connection with the forum state are such that he should reasonably anticipate being hailed into the court there. So your client sells this insurance. These people are traveling. He knows that's the whole reason they're buying the insurance. Your client basically negotiates with the hospitals to try to get the amount that they will take down. Certainly your client has to expect to be hailed into the court when these negotiations break down, or if it fails to make payment.
Not necessarily, Your Honor. There has to be, again, foreseeability. And in this case, there's not. There's no. The Erie case
Wait a minute. It's not foreseeable that if your client doesn't pay the hospital bill for its insureds, it's going to get sued
No,
in the
it's not.
jurisdiction where your insureds were treated.
No, because that's based on the unilateral act of the insureds. So again, this is not a
But
purposeful.
that was the unilateral act that they bought the insurance to be able to cover.
Okay, but there's nothing been established in the complaint that says that insurance was bought in Florida. That insurance was bought in the United Kingdom. In fact, the complaint says specifically that this foreign travel insurance was sold to foreign patients for purposes of traveling. Again, there's no allegation that the foreign insurer had any idea where these insureds were traveling. And again, in the Erie case, even if the defendant might foresee that its insureds might travel to Florida, the unilateral activity of the insured is not sufficient for personal jurisdiction. The court in that case specifically held that the mere provision of coverage for actions nationwide is not enough standing alone to confer jurisdiction over a non-resident insurer that has not otherwise taken steps to purposely avail itself. We need to focus on what's being pled in the complaint. There's nothing pled in the complaint that's saying that my client the foreign insurer had any idea where these individuals were traveling. In fact, the complete opposite, that plaintiff's complaint says that the foreign insurer is a corporation existing under the laws of Florida, that the foreign insurer agreed to provide foreign travel insurance to cover various foreign residents. There's nothing in the complaint saying that the insurer had any idea where these individuals were traveling. There's no
Well, it's safe
contact.
to assume that the insurer knew they were going to travel outside of the United Kingdom, isn't it?
Of course, but does that mean that the foreign insurer is subject to jurisdiction anywhere in the world that the foreign insureds unilaterally decide to travel? The case law says the complete opposite. In fact, the plaintiff's complaint, again, says that NCH, the hospital, is not a participating provider with the insurer, that the foreign insurer did not have any participating hospitals in the geographic region that the Naples hospital is located. And moreover, the Florida courts
Your
have consistently.
client paid the claims. Your client doesn't seem to be disputing coverage anyway. And that is a troubling fact. And that's alleged in the complaint relative to your argument. If your client truly believed that this was not something that it was answerable for, why would it have covered the claims at all?
Well, again, this is based on specific jurisdiction, so that it would have to arise from the actual claim itself. These are you're referring to subsequent acts that were taken after the actual cause of action.
Well, I'm referring to what's alleged in the complaint, which is all the trial judge had in the way of a factual basis to determine jurisdiction.
Of course, but again, what is pled in the complaint is insufficient. There is not due process considered, similar to what was considered in this very court in the Osborne case, that would establish that there's consideration for due process here.
Sir, would you have a better argument if you had filed an affidavit setting forth that you had absolutely no offices in the state of Florida, the United States, you had no representatives selling policies there, you had no third-party providers in the United States, much less the state of Florida? Wouldn't you be in a better position?
Your Honor,
Because this complaint specifically alleges Collier County with specificity. And that's what the judge was looking at. And when she looked over at travel insurance's attorney at the hearing, you got nothing. You just have an argument. She's supposed to look at this complaint and assume that it's true.
And we are, Your Honor. I would be lying if I said that that an affidavit wouldn't hurt. It wouldn't hurt at all. But again, I think that there are insufficient allegations in the complaint as is to subject this client. The plaintiff has to demonstrate that there are due process, the minimum contacts here. Foreseeability does not define the limits of due process. Which is based on the non-resident defendant purposeful contact with the state rather than the mere foreseeability. This is all based on the unilateral acts of the insured in deciding to travel to Florida. The court in American Express versus Duval, that court noted that there was nothing in the record that the insurance contract was executed anywhere other than the UK. No indication that the defendant knew that the insureds were traveling to Florida or finding themselves in Florida more than any other popular destination. Similarly, there's nothing in the record that the court demonstrated by the plaintiff that the insurance contract was entered anywhere other than the UK. The fact is completely opposite and demonstrated by the plaintiff's complaint. Again, this is a United Kingdom insurance company.
Well, but you just argued that the contract was executed in the UK, but the complaint says that the contracts and services upon which this action is based were entered into and were performed in whole or part Collier County. Now you're going to say that's false, but you didn't offer any record evidence to prove otherwise.
Well, I'm going to argue that again, the Osborne case that was decided by this case, that this court, that complaint alleged that at the time that the contract was entered, the plaintiff and the defendant were domiciled in Punta Gorda, that he signed the contract in Punta Gorda, and that although the contract was silent as to the place of payment, the society had made all payments in Punta Gorda. This particular court ruled that was not enough because minimum contacts were not established.
Let me ask you a different question. This complaint is loaded up with allegations that the plaintiff is a third-party beneficiary of the agreement. And again, those are the allegations and those are the facts. The trial judge was bound to accept those as true. And the facts underlying the legal conclusion about a third-party beneficiary, how I'm struggling to figure out how the trial judge erred on the record before her, which was this complaint. And we can argue, and you can argue all day long, but as Judge Sleet pointed out, I think your client put itself at risk going into a Venetian salami hearing without an affidavit to set forth its version of the facts as to why the long arm statute wasn't satisfied.
Well, we would argue that the court erred by simply stating that by making payments, the foreign insurer subjected itself to this jurisdiction. As far as the allegations in the complaint, as you said it yourself, this is based on a assignment of benefits as a third-party beneficiary. There's nothing alleged saying that my client went into Florida and purposely availed themselves. In fact, like I said, that the complaint alleges that there's no participating providers by my client, that what they're doing is actually unlawful.
Your client didn't issue a strict PPO policy. It wasn't an HMO type policy where they would not have coverage if they went to a non-participating provider. That argument doesn't seem to stand up to me. Tell me why I'm wrong.
Sorry, Your Honor, I didn't really follow.
The policy, it would be one thing if your client had issued what amounted to an HMO policy and the only providers that the insureds could be treated by were those specified. This wasn't that. Which is why I don't think this argument holds up. This was a more generalized coverage, like a Cadillac PPO policy where, if they're not a participating provider, maybe we don't reimburse fully, but there's no coverage.
Well, that claim is more so going to the lack of minimum contacts. Again, we're focused on the minimum contacts here, and the fact that there's no participating providers just further shows that these two entities are not related, that they haven't been doing business. The Venetian Solomani case specifically says that the prior relationship and the future consequences are what governs, not necessarily the fact that there's just a contract. And there's nothing here that that TIF had any express agreements with NCH. There's no contract with the Florida resident. There's no allegations that there was any agreements between the parties, but for the assignment of benefits signed by the insured after they unilaterally decided to travel to Florida.
You're right at your 15 minutes.
Okay,
Just so you know.
in concluding, while I would like a 5-minute rebuttal, the appellant requests that the court rule consistent with this court's ruling in the Osborne case, and finding that there's nothing in the complaint which would indicate that TIF was availing itself of the privilege of conducting activities. Again, foreseeability is not the only rule here. So I thank you for your time.
Okay. Thank you, sir. You'll have 5 minutes when we return. Mr. Hartley?
Thank you, Your Honor. May it please the court, Tim Hartley for Naples Community Hospital. And as a preliminary matter, I appreciate the panel allowing us to argue this matter because this is a very important issue for Florida. We have a lot of tourists that come to Florida. And as was set out in the preamble of our reply brief, of our answer brief, this particular issue happens every day in every hospital in Florida. Now, this particular complaint deals with 21 different patients with over $246,000 worth of unpaid claims. The complaint, and I know this is not part of the record, but the complaint has since been amended to add another 10 patients, and now we're up over $450,000 in claims. So for TIF, who Judge Morris, as you exactly pointed out right on point at the beginning, you saw the issue here. This is a company that issues insurance policies for one purpose and one purpose only, and that is to cover medical expenses for travelers. Do they know these people are coming to Florida? Absolutely they do. In fact, paragraph 7 of the complaint specifically alleges TIFs and or unknown insurers' insurance policies are directly intended to cover the patients for hospital services provided by NCH. In fact, these insurance policies, if you read the language of them, and again, this is not part of the record because we didn't have to get this far in the hearing, but the policy coverage for emergency medical care does not even come into effect until these insureds leave their home country. So like the case that was cited in the answer brief dealing with Elvia, where the insurance coverage did not take effect until someone rented a car in the United States, and in Florida, the insurance coverage in this case will not even come into effect until a person travels outside of their home jurisdiction and incurs medical expenses. The reason this is important, though, is that what is going to happen once COVID hopefully opens up is you're going to see a flood of tourists coming to the United States. You're going to see them coming from the UK, coming from Canada, coming from Europe. And not only TIF, but all of the other foreign insurance companies that it represents and work with are going to use the same argument. They're going to say, when our patients come and seek treatment in Florida and provide the admissions office with an admissions card that says this person is covered by TIF insurance or whatever company insurance coverage it is, you, hospital, are authorized to treat this patient and to send us a bill. And yet when the bill is sent and it's not paid or it's underpaid, then they go back to their policy and they say, wait a minute, you have to now sue us in the UK or the Channel Islands. It's sort of misleading for an insurance company to say, on one hand, you are covered. And as has been cited by TIF in its Erie Insurance Exchange case, this is one of the cases that they relied upon in their initial brief. Couchon Insurance says, and again, this is at page 152 of the opinion, that when no place of performance is specified in an insurance policy, the insurer must make payment in the state where the insurer resides. Now, in this case, although these individuals may reside in the UK, we're arguing under an assignment of benefits policy. We're arguing as a contracted party pursuant to an assignment of benefits, and it is axiomatic that any insurance that any services that are provided to these insureds take place in Florida. So since
Mr. Hartley, I appreciate your argument and I appreciate your poster back there, but is this the case? This isn't teed up for what you're talking about because we're at the pleading stage where he did not file any affidavit whatsoever. So it really hasn't been ferreted out by the trial court whether or not there's any long-arm jurisdiction. Now, obviously, he's seeking an outright reversal. That's problematic. But I appreciate what you're saying. 20 minutes is very fast. So I'm not sure this is the case that's teed up for what you're talking about.
Judge, thank you very much. And again,
And Mr. Hartley, I might add, I would think that TIF's worst nightmare is for them to win this case, because this will spread like wildfire through the hospital industry in Florida, and they will be out of business in Florida, but that's just my 2 cents.
Judge, and I will tell you and to address Judge Sleet's point, and we had filed a motion to dismiss this appeal for mootness. And the reason is that since the filing of the appeal, there's been an amended complaint filed, there's been jurisdictional discovery that's taken place. There have been other issues that expand what we're talking about. But on its face, unless these allegations are contravened or countervailed by an opposing affidavit, they have to be admitted as true. And as has been set forth in paragraphs 5 through 10, we have talked about the business relationship between TIF and NCH. And at the end of the day, there is nothing on the record that fights that refutes that. There's a mere legal argument, but there's no factual support for that argument. I've come to have a lot of respect for Judge Cryer. She calls them like she sees them. And in the hearing, and this is in the appendix, her response to TIF's argument was that this is ridiculous. She saw, before we got too deep into this, that these policies are intended for one purpose and one purpose only, and that is to cover travelers who have emergency medical needs and who come to Florida, and to argue otherwise is ridiculous. So until there are some facts that support TIF's position, we would respectfully ask this court to uphold Judge Cryer's denial of the motion to dismiss. Thank you.
Okay, thank you, sir. Sir, you have 5 minutes.
Thank you. Again, Your Honors, after hearing Appellee's response here, I think we're really focusing on the lack of the affidavit here. The courts have specifically held that it is plaintiff's burden to demonstrate both the sufficiency and the meaning of the long arm statute, as well as the due process rights that come with minimum contacts. The focus of the—
But in those cases where they've held that, was an affidavit filed?
In the Osborne case, there is no mention of an affidavit.
Well, frankly, it's highly unusual that affidavit is not filed. I mean, that's the immediate surprise in reading this case, is that there was no affidavit filed, and that really almost ties your hands coming out of the gate, to be honest.
Well, of course, but again, if we need to focus on what is being alleged in the complaint, and if we want to focus on paragraph 5 and the intention to cover the patients, the intention is to cover patients worldwide. So again, that comes back to the argument of, if we're going to go to the intention of the insurance company, the intention is to cover patients worldwide, which the Florida case law specifically says is not good enough. It's too broad. It's insufficient. It's just against fairness to subject this particular insurer to jurisdiction worldwide. And in the Elvia case that was cited by Appellee, in that case, the insurance policy explicitly provided insurance for treatment in Florida. Again, there's no allegation here that this policy explicitly provided insurance coverage for insureds in Florida. It says that they intend to cover the insureds in this case. Well, they intend to cover the insureds whether they're in Florida or Hawaii or China or Germany. There's nothing in the complaint that says specifically where what's included in the policy. In fact, the policy isn't even included in the complaint, so we have no idea what the policy says. The plaintiff argued that the insurer should have foreseen that one of its insured would travel to Florida and get into an accident, and hence foreseen that litigation might ensue. That again is completely contrary to due process here. Lastly, again, the court in Elvia, the court held that the mere provision of coverage for actions nationwide is not enough, standing alone. So again, we would request that this court would reverse, and I apologize for misstating earlier. We would request that they reverse and remand to the lower court for ruling. And I thank you for your time.
Thank you both very much. Interesting case, very interesting issue.
Thank you.
The panel, okay.